Hello and welcome to this summary of our 11th annual Employment Law Breakfast Briefing. This is a summary of an in-person event that we recently held, highlighting some of the key employment law decisions from 2022 that you need to be aware of and some of the forthcoming developments for the coming year. So my name is Ian McRae. I'm a partner in the employment law team here at Field Seymour Parks. Let's take a look at what we're going to cover in this session today. So first thing, as I say, we've got three cases that I've picked from 2022 that I want to talk to you about relating to redundancy, without prejudice conversations and holiday pay. And then we'll go forward and look at some of the key developments that are in the pipeline for this year, 2023, and indeed beyond. So if we crack on and start with one of those key cases, this is the case of Mogane versus Bradford teaching hospitals. It's a redundancy case and it's an employment appeal tribunal decision from 2022. So if I give you the facts of the case to start with, or a summary of them at least, the claimant in this case was a nurse, a band 6 nurse, and they were employed on a series of fixed term contracts. There was another band 6 nurse employed within the teaching hospitals who was also on a series of fixed term contracts. Now, the claimant was invited to a meeting, advised that the teaching hospitals were in financial difficulties, and then shortly afterwards it was decided that the claimant was going to be made redundant. Now, the thing that's interesting about this case is the reason for that. So the reason given by the employer in this case was that her contract was the one that was due to be renewed the soonest. It was due to expire the first. That was the sole criteria used. A redundancy process was followed, but that focused solely on alternatives to redundancy, and ultimately the employee was dismissed, and she brings a claim for unfair dismissal, and it ends up before the Employment Appeal Tribunal. Now, what the Employment Appeal Tribunal decides is that that dismissal was unfair, and there's a number of key points that they make in reaching that decision. First one is that they say that consultation must take place when the outcome can still be influenced. If you start after that point, then that consultation is meaningless and you're going to end up with an unfair dismissal. Also, the implied term that is implied into every employment contract, which basically says that the employer should not act in a manner that is calculated or likely to cause a breakdown in the relationship of trust and confidence. That implied term extends to ensuring that the employer should not arbitrarily choose the selection method for redundancy. And they made this sort of comment, which I've given you the quote on the slide there, which is saying that a pool of one, so only one individual can be considered for redundancy, that can be appropriate, but it shouldn't be considered without prior consultation where there is more than one employee. So what does this all mean? Well, there's a lot of commentary around this case last year. A lot of people suggesting that you can't ever have a pool of one employee for redundancy without prior consultation, which might mean that every time you think you've got a unique role that is at risk of redundancy, you might need to consult about that point, about that pool, whether or not it's a unique role before you do anything else. And other suggestions that you always have to consult on the criteria themselves that you're proposing to use before you actually carry out your scoring process. However, I think the key thing to know with this case is it is useful, but the circumstances here are quite rare. You did have a potential pool of 2 employees. You had 2 of these band 6 nurses on these fixed term contracts. The employer here used a single criteria. It was about expiry of contracts, and there wasn't much to consult about once that criteria had been chosen, because it automatically resulted in one individual being selected. There wasn't any subsequent consultation about the pool or whether it should just be one individual at risk. And there wasn't really any rationale given for the criteria that was used in this case. So the key things I would say you need to take away from this case is that if you are using criteria that are going to automatically lead to someone being selected, then I think you do need to consult about that before you use them. So in this case, obviously, we had the contract renewal dates, which are a set date, not much to talk about there. It's not like performance where you could have a discussion about how well someone is performing. It's a set factual figure. You could also have things like length of service, or maybe even disciplinary record, where it's quite obvious that there's one individual with a poor record and everybody else has clean records. Again, that might automatically lead to someone being selected. And in those circumstances, I think you need to talk about those criteria before you automatically move through to sort of a provisional selection. You should also always ensure that consultation about a pool is part of your process. So even if you think you have an employee who carries out a unique role and they're the only person who should be considered for redundancy, it is still wise to set out your rationale to the employee and allow them to put forward their views on that as part of the consultation. You may not agree with them, but it is wise to include that as part of the process. And also for business and indeed legal reasons, it makes sense to use redundancy rationale that makes sense. Obviously, when you are making redundancies, you want to keep the best people who are going to add value to the business. It therefore makes sense to have rationale when selecting people that take into account performance or qualification or other key things. Sometimes it can be tempting to choose something that is very clear and simple, like a contract renewal date, but you do run the risk of that being challenged as an arbitrary selection process, or you may just end up with retaining the wrong people in the organization, which obviously has business issues as well. So moving on, away from redundancy and towards without prejudice conversations. Now, this was an important case last year, essentially on the ability of employers to be able to have sort of off-the-record conversations with employees about an exit from an organisation. Another employment appeal tribunal decision. And as many of you will be aware, in very simple terms, there are two ways you can have a off-the-record conversation with an employee. And by that, in simple terms, I mean a conversation that the employee cannot rely upon in support of a claim. And as I say, two ways. One is this section 111A of the Employment Rights Act. Often called protected conversations, pre-termination negotiations, protected discussions. And that is a way of having a conversation with an employee about them leaving the organisation, but it's only not disclosable for normal unfair dismissal cases. So if the employee wants to rely upon it for a discrimination claim, a detriment claim, an automatic unfair dismissal claim, that's not going to help you. It's still going to be admissible. So it has its limitations. The second way you can potentially do it, which is the focus of this case, is a without prejudice discussion. Long-held principle that when parties are having discussions and it is a genuine attempt to settle an existing dispute, that those conversations may be inadmissible in court or tribunal proceedings. Doesn't just apply to employment law, it applies to all manner of civil disputes. Now, the problem with without prejudice communication, or one of them in an employment contract, is this case of BNP Paribas versus Mezzotero. Now, in that case, Ms. Mezzotero raised a grievance. It's all about not being able to return to her old job after maternity leave. They have a purported without prejudice meeting. Job is no longer viable, best for everyone if we reach a settlement, but no settlement is reached. Employee brings discrimination claims, and the Employment Appeal Tribunal makes this finding that just because an employee has raised a grievance, it doesn't necessarily mean that there is a dispute for without prejudice conversation basis. And as I say, without an existing dispute, you could not have a without prejudice conversation, and therefore you cannot have something that is potentially inadmissible. And the reason for this decision, in simple terms, was the employment relationship is ongoing, the grievance could potentially be resolved, which is, in theory, the purpose of every grievance process is to try and resolve an issue, and therefore there was no dispute for you to have a without prejudice conversation. Now, that was taken as meaning by a lot of people that it was very difficult to have a without prejudice conversation when employment relationship is ongoing. Now, in this case, the Garrod versus Riverstone management case, Similar facts in a way. Employee Garrod submits a grievance, allegations of discrimination against 3 managers concerning maternity, bullying, harassment. And she has a meeting with the company and their external HR advisor. They talk about the grievance, and then the external HR advisor says, I'd like to have a without prejudice discussion. They describe the employment relationship as fractured and problematic, and they offer £80,000 to terminate by way of a settlement. Obviously, as you can guess, no agreement reached, ends up in the courts, and the claimant has bringing claims of discrimination and constructive unfair dismissal. And there's 2 key points in this, and the claimant says the contents of that meeting are disclosable, i.e. I can rely upon them in support of my discrimination claim, because there was no dispute at the time the conversation took place, relying upon the Mezzo-Terro earlier decision, and it was also unambiguously improper for the employer to imply that they had no future. Now, the ruling of the Employment Appeal Tribunal quite useful, because what they say is the Mezzo-Terro case, they clarified it, and they basically said that case does not say that a grievance can never be a dispute. So you can potentially have a dispute when there is a grievance pending. The facts were slightly different. In the Mezzo-Terro case, the meeting itself was a fundamental part of the claim, and if that was inadmissible, there wasn't too much else for that claim to proceed on. Here, actually, the meeting was not fundamental to it. It was actually the contents of the grievance that formed the basis for the claim. So the fact that this meeting was not disclosable didn't defeat the claim in itself. And the Employment Appeal Tribunal also concluded that the meeting was conducted appropriately. So the key message of this is without prejudice conversations are possible even where there is ongoing employment, but you do need to proceed with caution. I've given you a few action points or things to think about for you to digest in your own time. But obviously, if you want it to be a without prejudice conversation, you do need to establish there is a dispute, and that will be fact specific. So do take advice on that before proceeding with what you think is a without prejudice conversation. In any event, you should always have a basis for that discussion, have some rationale for what you're putting forward. It's normally wise to assume what you're going to say is disclosable, so don't make any threats or apply undue pressure. Get the labelling right. If you want it to be without prejudice, make it clear that's what you consider it to be, although be aware that that is not conclusive in itself. The employee should be aware what that terminology means, though, so you need to make it clear that you're going to consider it inadmissible if there were court or tribunal proceedings. Keep records of it, allow the employee time to consider any proposal. Keep settlement and open discussions separate, and think about giving them the right to be accompanied at that meeting as well. Short thing is to take advice on the circumstances, but a few key things to consider before you proceed with those types of discussions. Right, I've got one final case I want to talk about from 2022, holiday pay case, Harper Trust. Lot of commentary on this last year, but there's a key reason why I want to bring it up now, as there may be some developments ahead. Simple facts for those of you who aren't aware of this: the claimant was a music teacher employed on a permanent irregular hours contract, so 0 hours contract, worked irregular hours throughout the year, and her holiday pay was calculated by the percentage method. So she basically accumulated holiday and pay depending upon the hours she worked, and they used a 12.07% calculation, which many of you may be familiar with. But what the claimant argued here is, no, that's not the correct method of calculation. You need to use the calendar week method set out in the Employment Rights Act, which in short says that holiday has to be calculated with reference to a reference period at the time the holiday is taken. At the time of this case, that reference period was 12 weeks. It's now been amended to 52 weeks, but the principle still remains. And what the Supreme Court found here, amongst many other things in a lengthy judgment, is that you do have to use the calendar week method. So you do need to calculate what holiday pay is at the time holiday is actually taken. And That calendar week method states that non-working weeks, so weeks where no work is carried out, should be disregarded for the purposes of working out that average pay. What that means, as the government has set out recently, is that this leads to more favourable treatment for some irregular hour workers. Because you're disregarding weeks they're not working, that pushes up their average pay during the reference period and leads to potentially more favourable treatment than sort of normal full-time workers. The reason I flag this in particular is the government has looked at this. They have just launched a consultation about it. They think it's benefiting between 320 and 500,000 employees, a lot of them in the education sector. And they've launched a consultation basically to see, take views on whether this sort of pro-ratering of holidays should be allowed and whether the calendar week method should in any event be amended so that non-working weeks are part of that consultation, thereby removing this potential advantage that irregular hour workers have. Key action points, if you haven't already looked at this following the case last year, you should carry out an audit of your holiday calculations and allowances for your irregular hour staff, if you have any. Other key points which really apply across the board on holiday, you need to ensure that holiday pay is linked to actual time off, so it's linked to a period away from work. Shouldn't rely upon the percentage method, or if you do, understand the risks that are involved in that. Ensure everyone is able to take 5.6 weeks leave a year, which is the statutory requirement. You need to calculate holiday pay at the time it is actually taken, and there are a few alternatives on that slide that you might want to consider. If this is causing you sufficient problems, you need to look at how you're structuring your employees. So that's enough looking backwards. Let's look ahead. Some key potential developments coming ahead this year, and the first one I want to talk about is the retained EU law bill. So basically, we left the European Union and the end of the transition period was at the end of December 2020. And at that point, in simple terms, all EU law was transferred into domestic law for certainty and ease. Now, this new bill is basically saying that all of that EU-derived legislation will be revoked, will no longer be enforced as of the 31st of December this year, unless it's been expressly preserved beforehand, or there has been this sunset provision, which is triggered, extending that revocation date through to the 23rd of June 2026. There's some other powers in there. The government's got the power to restate EU law or to replace it. It's easier for the courts to depart from previous European Union decisions, and also easier for the government to amend legislation that's come from the European Union. Now, quite a hostile reaction to this, splitting across not just the classic sort of Remainer leaver lines. I've given you a few quotes on there, which I won't repeat. But ultimately, the criticism comes down to four things in very simple terms. One is whether there is enough time to consider all of this European legislation before this deadline. Two is the uncertainty that these changes will produce. Third is the risk of watering down protections, which can include employment protections, but also other areas of law as well. And then four, the way this bill is structured, it passes a lot of power to the government rather than to Parliament. So what should you do about this? Well, the reality is there's not too much to do right now, because we need to wait and see how this bill progresses and how it will impact upon employment law. I've given you some examples on the slide of some of the types of legislation that could be impacted or could be no more at the end of December. We have to wait and see. So a lot of commentary from people. I've given you a quote there from George Freeman, where he is suggesting a slightly more focused approach than revoking the entirety of EU-derived legislation. But in short, sign up to our updates and keep an eye on this one as it develops over the course of the year. Right, another hot political topic next for you, which is about strikes and trade union laws. So on this slide, I have given you possibly the simplest introduction to the laws related to strikes and industrial action that I could manage. But the key thing to realise is that trade unions can be liable for endorsing strike action unless certain legal requirements are met. The most commonly understood one is about having a properly conducted ballot of their members. If they don't get those legal requirements right, then they can be liable to the employer for the damages they suffer as a result of the strike, and also the employer could potentially get an injunction preventing the strike completely. Also, risks for employees: they get certain protections if they are taking part in strike action that is properly coordinated and meets those legal requirements. If it doesn't meet those legal requirements, then potentially they could be dismissed. Now, that's your backdrop in very simple terms. We've obviously seen a rise in strike action in the second half of 2022, and that has led to this bill being introduced before Parliament. There was a promise of sorts in the Conservative 2019 manifesto of similar legislation, but this bill goes much further. And what essentially it permits is for the Secretary of State to pass regulations prescribing minimum service levels in certain sectors of the economy. There's an obligation on the Secretary of State to consult such persons as they consider appropriate before passing those regulations. But what essentially it leads to is when trade unions want to call a strike, in simple terms, they have to serve a strike notice on the relevant employers. But what this would allow is for those employers to counter that notice with their own work notice. And that would identify that the workers that are required to meet these minimum service levels and the work that's required to undertake them. The employer has to consult with the union about that work notice, and it only has to cover those workers that are reasonably necessary. But the key thing is, if the trade unions do not comply with those minimum service levels or with that work notice, then they can lose immunity from action from the employers, and the employees can may lose their unfair dismissal protections. Lots of commentary about this. There are duties to consult, but ultimately the Secretary of State and the employer have the final say under the bill as currently proposed. I've given you some of the benefits and negatives on the slide there. There are concerns that this might lead to an increase in other forms of industrial action, maybe a decline in overtime or similar, or that strikes will take place with greater frequency if they have less impact. Wait to see. The bill is progressing through Parliament. We'll wait to see if it passes and its final form, as some amendments may well be made. There's a couple of other developments expected in respect to trade unions, which I have placed on that slide there, which we will deal with in our updates throughout the year as they happen. Right, moving on, sexual harassment, and we have a private members bill before Parliament. It is being supported by the government though, and it basically is creating 4 new sort of legislative developments. The first one is creating an employer's liability for third-party actions. It's introducing a positive duty on employers to take all reasonable steps to prevent sexual harassment. It makes provision for enforcement of those duties, and there's also a provision in there for compensatory uplift in the event that a claim is made out. Now, this may pass this year. It's likely not to be effective until 2024, but it would be wise for you to be applying your mind to your policies dealing with sexual harassment and your processes well in advance of that. On this slide, I've given you a few things to think about that you might want to include in your policies. For example, it's important to be clear to your employees the extent of the issue. There's all sorts of statistics out there. There was a piece of BBC research recently that suggested 40% of women and 18% of men had suffered sexual harassment at some point in the workplace. You need to make sure your employees understand that this is something that can arise. You need to talk about who is covered, which may be a little bit wider than you would normally have. A lot of HR policies are focused on the actions of employees. Obviously, this bill is creating potential liability for the actions of third parties, maybe your customers, maybe your suppliers, and therefore you're going to need to bind them into this as well. Think about your organization, think about the risks, and tailor your policies appropriately. You've got a duty to take reasonable steps to prevent sexual harassment. You can't really do that until you've identified where those risks potentially lie in your organization. You may have had complaints previously, which will give you some indication of where those risks lie. Be clear on the standards expected and give examples, and be clear on the consequences in the event that sexual harassment takes place. Now, that may be very easy for your employees. They may face summary dismissal for gross misconduct, but what if it's a self-employed contractor? What if it's a client? What if it's a supplier? You need to apply your mind in terms of how you are going to take actions in the event of a complaint against one of those is well made out. You're going to need approval from the top. So think about clear board level sign off and buy-in. You should have a variety of reporting options, including anonymous ones. Keep under review whether your policies are effective. That can be difficult, but a regular review and a review after complaints together with staff surveys can help. You're going to need to have training that is relevant to your organization. And that final point, and perhaps the trickiest one, is just thinking about how you're going to deal with some of those third parties. I've talked about suppliers and customers here, but your organization might have other ones where there's a risk. You may need to think about contractual obligations on them to comply with legislation, to comply with your policy, to cooperate with investigations. If you do want to introduce contractual changes, you may need to do that sooner rather than later, particularly if you have long service contracts in place. We wait to see how that bill progresses through Parliament. Flexible working. So towards the end of 2022, we had the government's response to their earlier consultation, and they have committed to a number of things, making changes to the legislation. Firstly, they're going to make the right to request flexible working a day one right, rather than requiring 26 weeks notice as it currently stands. An obligation on employers to consult if they're considering rejecting a request. An ability to make 2 flexible working requests in a 12-month period rather than 1 as it currently stands, and the period to respond reduced to 2 months rather than 3. And also a reduced requirement for what the employees need to put in that flexible working request. So much like the earlier sexual harassment, the government is proposing that these changes are made by supporting a private member's bill. Giving you details of the bill on there. That bill in its current format at the time of recording does not make provision for the change to day one, to being a day one right. It does cover the other points, but it doesn't include that. And the suggestion is that once this bill passed, there'll then be some further regulations which will provide for that formal flexible working request to be made on day one of employment. That appears to be the intention of the government. It just adds a further layer of uncertainty as to when these changes will actually be introduced. So this is one to watch. Keep an eye on our updates, but as and when it lands, or we know it's going to land, you're going to need to update your policies, any standard forms, and think about training for your organization as well. You're going to have reduced timeframes potentially for dealing with these requests, so you're going to need to get a move on much quicker. So if you've got a manager sitting on it for 2 weeks, that is not going to be helpful. A few different changes ahead in respect to different types of leave that may be available, which I'll highlight over the next few slides. First one is the carers leave bill. Again, another private member's bill supported by the government. And it provides for 1 week's unpaid leave a year for employees who have caring responsibilities. This one is a day one right. And it's designed to be taken flexibly with no requirements for evidence of how the leave is to be used or for whom. So quite easy to take is the intention. And there will also be some protections in place for employees that choose to take that leave. So protection from detriment and dismissal. Timeline again, and this is unclear, had its second reading before Parliament back in October 2022, and we expect that to progress through Parliament this year. Another type of leave and another bill that is a private member's bill supported by the government. Neonatal care leave and pay bill. And this is providing for 12 weeks of paid leave. And this is for parents to spend time with their baby who has been born prematurely or sick and is receiving neonatal care. It's in addition to other leave requirements, so for example, maternity leave. It will be day one right in respect of leave. There is a proposed qualifying period for the pay, and there's some criteria that need to be met if you have an employee who wants to take this type of leave. There's likely to be a delay on this. Firstly, the bill's actually got to pass through Parliament, so we wait for that to progress. It does then likely to be a further delay after that. We are dealing with paid leave. That requires some adjustments with HMRC and others, and therefore you may have a longer time frame until this comes into effect, but one to keep an eye on. Couple of other bills which I will mention relating to paid time off in the event of miscarriage or for fertility treatment. That again, there are private members' bills pending on these. They do not at the time of recording have government support, and accordingly it's anticipated that they may move somewhat slowly, but I think it's appropriate to mention them here as they are proposed and they are before Parliament. As and when these different types of leave come into effect, you've obviously got policy updates to do, but you're also going to need to raise awareness and have training amongst your organisation. It's going to be increasingly crucial with many different types of leave, with different rights, different levels of pay, that you are correctly logging what leave your employees are taking and when. Right, got a few other areas to watch before I sort of wrap up. First one is the holiday pace of Agnew. This was heard in December last year. We're expecting an outcome of it soon, and this will hopefully give some further clarity on how far back employees can go with historical holiday pay claims. Should hopefully come out in the sort of first quarter of 2023. There's another private members bill backed by the government currently before Parliament. As some of you may be aware, that if you are thinking about making a woman on maternity leave redundant, then you need to offer a suitable alternative vacancy where one is available. This bill, in very simple terms, looks to extend that protection out to those who are taking shared parental leave or are on adoption leave, and is designed to extend that protected period as well, to help cover those who miscarry, and to extend the protected period for its anticipated 6 months after return from maternity leave. So we wait developments on that. There's another private members bill relating to tipping. Won't go into the detail here, but it's trying to ensure that 100% of tips are passed through to staff. Bill of Rights to replace the Human Rights Act. This comes on and off the agenda. It seemed to be shelved by Liz Truss last year, but now may be back on the agenda again. This is an important one to watch from an employment law perspective. It will take time to progress, even with government support, but it may sort of water down or impact on how human rights, such as the right to private life and family life that derives from the Human Rights Convention, are incorporated into UK law. One that has a lot of impact upon, for example, things like monitoring of employees. So that's an area to watch. We wait to see how that develops over the year. We are awaiting a code of practice on fire and rehire, which was promised last summer following the P&O controversy, which many of you have seen in the press. We are still awaiting that, but hopefully that will come through the government at some point. Data protection, government still plans to replace UK GDPR, and there should be an update on that later this year, although that will take some time to do. But there's also some consultations ongoing by the Information Commissioner's Officer with a view to producing a new employment code of practice. As and when that becomes live, that will be important for all employers to read and comply with. So watch this space. We have an additional bank holiday this year on the 8th of May, although employers are probably used to that, as we obviously had 2 last year. And there's the normal sort of change in rates that will take place in April. So watch out for those national minimum wage, a week's pay for redundancy payments, things of that nature. A couple of reminders. These aren't really newsworthy almost in a way, but important to remember. Back when Kwasi Kwarteng was Chancellor last year, he announced that there was likely to be a repeal of the off-payroll rules. which you may remember relate to who has responsibility for ensuring that proper tax is deducted for IR35 when individuals are providing consultancy services through their personal service company or another intermediary. Just to be clear, that legislation has not been repealed or revoked. Jeremy Hunt, when he became Chancellor shortly after Kwasi Kwarteng, said that there was going to be no change, and no change has taken place as of yet. So you still need to comply with that. And also there were changes to right to work checks in October, where the COVID rules fell away and we went back to a normal regime, although with the possibility of some online checks for certain things. If you're interested in that or you haven't yet changed your practices, then there's a lovely 10-minute video that my colleague has done on our website, which is worthwhile you having a read. Right, usual caveat on this, very brief summary, as I'm sure you can appreciate, of some of those developments and changes that are potentially planned. Always take legal advice on your own particular circumstances, and I have summarized it as of correct at the time of recording, but a number of these things are moving quite quickly. So please do sign up to our updates. You can find the sign up form on our website, and we will keep you abreast of the key changes. But thank you for attending this session, and I hope you found it useful.